double up. Yeah. Double up. The money I cuddle up.
Hi, this is Rita Super, and welcome to Let's Talk Money with my co-host Lerone Brown and special guest Kirton Madison Esquire, founder and partner with Madison Law PLLC, with offices in Charlotte, North Carolina, and Atlanta, Georgia. Today, Kirton will talk about ADAs, workplace accommodations, and how to address employer pushback. With that said, I am passing the mic to Kirton.
Hi, okay, it's my first time doing this, so bear with me a little. Um,
Sure.
so I'm an employment attorney. I'm licensed, currently only licensed in North Carolina at the moment. Wanted to talk briefly today about the ADA accommodation process. Uh, Honestly, most of the calls I get have to do with the ADA. I do mostly discrimination, harassment, employment. I only represent employees. So I'm always on this side of the fence against corporate America, against the employer. And it actually helps a lot. Like the more educated employees are, the better they're able to assert their rights and the better they are better position they're in when they come to me and they need advice, they need an attorney, and they need to move forward with the claim. So ADA, Americans with Disability Act, it protects employees. Uh, it provides, protections for employees, specifically in the workplace. So if you have a condition, say like you have a medical condition, um, you can go to your employer and request that an accommodation. Okay, if you need some sort of assistance in performing your job. Okay, and that can look like a variety of things. It could look like, hey, maybe you need to work from home. Maybe you need a special device to help you perform your job. Maybe you need to change your work schedule. Um, Maybe you need a special chair. It could be a list of things, but something that allows you, if you have a condition, a medical condition, and it's hindering your ability to perform your job, you may be able to talk to your doctor about requesting an accommodation with your employer. Okay, so the accommodation request process is an interactive process, so it should be some sort of back and forth between you and your employer. It shouldn't be like, okay, I want to work from home and your employer just says no. There should be some sort of back and forth. The way you are able to accomplish this, the best way is for you to talk to your employer about what the essential functions of your job entail. Okay, is it like sitting at a desk, working at a computer? Are you talking on the phone? Like what it is? Are you lifting? Like, and how will this accommodation allow you to perform those functions of your job? Um, and
Excuse me.
so, I'm
Excuse
sorry,
me
go
for
ahead.
1 second. I'm sorry. Okay. Um, are you required to disclose your disabilities when you apply for the job?
No, no, not at all. And actually, they can't ask you about your disability, even if you come in there using a cane, they can't ask you about your disability during the job hiring process. Now, they may ask specific questions about, specific tasks you may have to perform during the job and ask you like, can you show us like they can ask like, are you able to perform these tasks or like, can you demonstrate how you perform these tasks? But as far as like your disability or like the extent of your disability, they can't touch on that at all. That would be a violation of the ADA.
That's interesting. So what about if you have a mental disability?
Um,
I mean, does
mhm.
ADA cover mental or is it only physical
No, it
disabilities
can
in the
cover
workplace?
mental as well. If it's preventing you from or it can affect your ability to perform the essential functions of your job, yeah, you can definitely get an accommodation for that. And it all depends on what the accommodation may look like. Okay. So, you say you have a mental disability, you may need more time to perform certain tasks. You may need like a separate, office space at times. You may need additional days off from work, you know, that and you know, like say your employer has a certain like number of vacation days that they allow, you know, and you may need additional days due to your, you know, mental disability. Like that can be, you know, your employer can allow that as a medical accommodation. The only time it comes into issue like is if the employer can argue that your requested accommodation creates a what they call an undue hardship for them. Whereas like, you know, it's impossible for them to continue to do business to employ you. And that's sort of like, you know, when I come in more often than not, is when the employer denies a request because under the ADA, they can, like I said, they can lawfully deny if it creates an undue hardship. And so it's a question of whether or not it does actually create an undue hardship. Um, like I said, some of the examples I gave earlier, like if your job is like talking on the phone or like working from your computer and your um, doctor wants you to work from home, requests that you work from home, and your employer says no. Okay, so what type of analysis did they do to decide that, hey, like this is going to create an undue hardship? Like, you know, you can talk on your phone, you know, work on your computer from pretty much anywhere. You know, what is the reason that's preventing them from allowing you to do this job, you know, at your home? And that's sort of like when we start digging in a little deeper to find out if this is something reasonable that the employer can provide you. Okay. And you know, once there's a process, so like I said, it should be an interactive process going back and forth. But once your accommodation request is denied, a lot of times what happens is, you know, employee with a disability, they may start missing work, you know, due to their health condition, their mental condition, whatever it may be. And that's when typically, you know, we will have to file a charge with like the Equal Employment Opportunity Commission, the EEOC, you know, some sort of discrimination claim against them. And with discrimination claims, with harassment, we have to um, exhaust all means of trying to resolve the matter before we can take it to trial. So we have to file with the EEOC, or you know, if there's some sort of like state commission, um, you know, State Department that handles these issues, we have to file a complaint with them in order, you know, and it has to go through that process before we can actually take the matter to trial. And so it's not a quick process usually. It's a it's a longer drawn out process because the EEOC can have a matter for up to 6 months before they will allow an attorney to take it to trial. Like they may allow it sooner, you know, but you know, I can request a right to sue letter, which gives me a right. It's a 90-day. Once you get a right to sue letter from the EEOC, you have 90 days to take the matter to trial. I'm sorry, I should back up for a minute to discuss that process. EEOC, you file a complaint with the EEOC, you know, with discrimination, you know, harassment, hostile work environment, whatever it may be. But the EEOC will investigate it. They will try to investigate it. You know, it's a federal agency. They have a ton of matters on their desk. It's just they have a bunch of tools at their disposal, but you know, it just depends on the investigator whether or not they're able to exercise all of them, you know, for each case. They usually try to get it resolved as soon as possible, but I've had matters that take up to a year or longer at the
Wow.
EEOC just to investigate. It's
So
not a
Curtin,
quick matter at all. I'm sorry.
okay, excuse me, Curtin, is it required, if you're gonna file an EEOC claim, is it required that you file with you notify your employer first?
No, 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 you don't have to at all. Um, you file with the EEOC will notify them. If you honestly, the way I like to handle things, if a employee comes to me, I will let the employee know, hey, before we file with the EEOC in an attempt to try to resolve it faster, if the employer is willing. Because like I said, the EEOC, it's a long drawn out process. A lot of employers know this, or then their attorneys know this. So they're like, look, we got some time once it gets to the EEOC. But the main thing is if you're having a issue with your employer, you don't want to wait. You know, if you have an issue, say like with them granting accommodation, but then retaliating against you for requesting accommodation, I'm sorry, I'm skipping over a whole lot of stuff.
That's okay. No,
I'm sorry.
slow down.
Okay,
You're fine. You're fine.
yeah. When you file a complaint or when you request an accommodation, you're automatically placed in a protected category. Okay. Some people don't like to file your so you're automatic if an employer demotes you, if they try to reduce your hours, they try to fire you, they take any sort of what we call an adverse employment action against you, they try to put you on in a position where you're not, getting the overtime you used to receive or making as much money, they're reducing your benefits in any way. That's what we call retaliation, and that's something that is actionable against them. So, once you file the complaint, if your employer takes any sort of adverse employment action against you, you have a period of 180 days. If you're in the South, some states are different. So in North Carolina, you got 180 days from the day they make that adverse employment action against you. Okay, whether they terminate you in employment, they demote you, they reduce your benefits, whatever. You have 180 days to file that complaint with the EEOC. All right. Because you're after that, if you don't file within that window, then you're cut off. You can't file with the EEOC, you can't file a lawsuit. Okay. So it's important to timing is important. Honestly, getting with an employment attorney is important because in my experience, employers, I've had like maybe I've been doing this since 20, I've been an attorney since 2011. I've been doing employment law since 20 what 14. I've had seen like maybe one time when an employer was like, okay, we messed up, we gonna make it right. Like they didn't admit it, like yo, like we could have done some things better. They ain't gonna say we messed up. We could have done some things better. Usually employers will deny, they'll try to make the employee seem like they're crazy. They will I say misplaced evidence, stuff like
Oh,
that. So it's the sooner you get with an attorney, the better off you'll be. Because I'll guide you. I'm like, look, you should you need this evidence, because stuff will disappear. Your email account will disappear. Employers will block you off. If they feel like you're in a position to sue them, they will cut you out. They'll cut off your access to email, they'll cut off your access to all files, everything. They'll do whatever they have to do to protect their name, okay, to protect you from suing them. So when someone comes to me, the sooner you come to me, the better, because I could advise you, okay, like, from our discussions, okay, you need copies of this, you need copies of these policies, these emails, all of that stuff. I'll make sure that you're actually documenting, your discussions with HR or with your boss about what happened. Okay, because employers will like to what they like to do is like to sit you down and say, hey, let's discuss. They don't want a paper trail, okay, at all of your discussions. So I ask that your request for an accommodation or your request for retaliation, whatever, your complaint be in email form and that you retain a copy of it. Also, any discussions that you have with them. If you're in North Carolina, it's a one-party consent state. So you record that. You record that, all your conversations with them about your request for anything going forward. You record those conversations. You don't have to let them know. You can record it. Or if you can't record it, what you do is following your discussion with your employer, you send an email to them summarizing everything that you all discussed. Okay. And, say, I just want to confirm, hey, we discussed, my request for an accommodation. You said you were going to do this. You want me to do this, take this action by this date. Is this your recollection of what we discussed? Okay. Oftentimes, they don't want to respond to that email. They'll say, hey, well, come and meet with me, it doesn't matter, let's talk about it. Doesn't matter. If they do that, first keep a track of that email. And then when you follow up discussion with them, send another email. Just keep doing that, create a paper trail. Um, because oftentimes in companies, they're well trained by attorneys, by corporate defense attorneys about that, not to actually leave a paper trail, not to have anything that might be used against them later on. Um, so yeah, it's like it's like a game. I mean, honestly, it's not a game because it's your life, it's your livelihood. But for attorneys, like especially on the other side, it's like back and forth, like, okay, make this move, I'm gonna make this move. Okay, because we're looking at the end game. Like we know how this is gonna play out in the courts. We've read, I don't know how many cases, we've read the law, we understand. Like it's a burden shifting um standard. Okay, your employer does this, what did you do? Okay, the employee did this, what did the employer do? It's back and forth, and
back
you
and forth.
really need, right, you need someone who can like guide you along, because a lot of times, employees, like, they're smart, but it's like you don't know this game. Like you may do something and it may make sense, it makes sense in your mind, but I'm telling you, as an outsider, as someone who has your best interest in mind, like, look, this is not the move you want to make. It looks good, at the moment, but it's not going to end well for you if you take this move, you know? Um, so yeah, I always advise someone to at least talk to an attorney early on. Um, and and honestly, like a lot of us, a lot of employee attorneys, we work on a contingency fee basis, or at least partially. Like a lot of times, if you're out of work or say like you're on leave, extended leave, you can't afford an attorney. So we're the type, like, look, we only get paid, or we get paid the most of our money if we win, or if we settle your matter. So we're not telling you anything wrong. We're not like, some attorney who's out there, just trying to run up, bills, and like just run up a check. Like, no, we're trying to get you as much as possible. We're trying to position you, you know, in put you in the best position to earn as much as possible, depending on, your case and whatever the factors are.
So, Mr.
So
Madison, I have a question for you.
Mhm.
My question is, what is your most common cases? You've been there for quite a while now. What are the most common cases that come over your desk? And what would be some of the things you look for that says, hey, employee, you might want to rethink this claim because maybe it's something that you may have done that escalated to this, like, and this may not be like a win in battle when you look into it. And I
Mhm.
understand you want to bring everybody to come, but then you might have some cases where somebody might just be having a bad day or they misheard or misinterpreted, cases like that. So, could you please elaborate how you would handle situations like those in your most common cases that you would see often?
A lot of the ones I get are like discrimination and retaliation.
Hmm.
Um, you know, um, I think people mess up when they don't want to use the word discrimination, especially with like race. They don't want to say that. They try to like make fancy, so like just basically skirt around it. And actually, like, no, I'm like, no, you need to say race discrimination, because your employer will, if you're not direct about it, your employer will say, well, we never knew about that. You never complained about that directly to us. I think that you're doing yourself a huge disservice by not saying that. With ADA claims, that's another big one that I get. When the employee, okay, so your doctor may make a request for a specific accommodation, right? But you're not entitled to that accommodation itself. Your employer should provide you with an accommodation that allows you to perform the essential functions of your job. Okay. So, um, you know, take for instance the working from home or whatever, right? Or yeah, let's take working from home. And your doctor say, hey, it's just easier if you work from home. Your employer can say no. They can say, hey, okay, so why do you specifically need to work from home? And it may be like, okay, well, there's too much dust or whatever in the workplace, and it affects my allergies. And your employer can say, well, we can put you in a room by yourself. We got like a HEPA filter in there, and it's not, you don't have to worry about that, you know? And like your doctor may agree to that, but the employee may say, well, no, my doctor said I need to work from home. Like, no, it's a back and forth process. It's not it's not just like I said on either side. It shouldn't just be like yes or no, like, hey, Like, this is all like you have to be willing to work with them, because like if you take that stance, um, yeah, you're more than likely you're gonna lose. Like, especially if you don't even try it. Like, your doctor may be reluctant and say, hey, I don't know, like, hey, like, that might be one of those instances where, hey, you need to try. Like, and if it aggravates your allergies, then you go back to your doctor, you go back to your boss, and you say, hey, this isn't working. Your doctor's like, yeah, this isn't working. There's too many allergens still in the room. It's still affecting them. We need to come up with something else, and that puts more pressure on your employer. Like, look, okay, so what is the undue hardship? Like, hey, this person still just, I understand you want them on site, but hey, like, they can't do it on site. Like, what is the reason? Like, and they got to come up with something, you know.
Yeah.
um, like, yeah, that's yeah, just you're kind of shooting yourself in the foot when you're not willing to at least like work with your employer. You want your employer to work with you, but you're not willing to work with them. That's not going to be looked upon well by the court, or even the EEOC. I've seen them just like kick it out, like, hey, you're this person didn't even attempt that. What they offered. They were just like, nah. So yeah.
That's interesting. So Curtin, can you just give us a recap or a checklist of what a prospective client needs to do to file a ADA, to file a suit
Okay.
claiming discrimination based on
Okay.
ADA, et cetera?
Okay. So first, you need to request the accommodation with your employer. Okay. Um, and if your employer denies the request, and it's a reasonable request, um, you know, um, I would follow up, with the employer again. Make sure you have your request in writing. Make sure, say, you send some sort of documentation to them as well to say, hey, I think this is discrimination. You guys have discriminated against me, under the ADA. Spell it out for them, you know? And if they still rebuff that, then you file your claim with the EEOC. Um, before, make sure you have copies of these records. Before all of this, like, I would definitely highly recommend that you contact an attorney, someone who guides you along, step by step. But that once your claim is filed with the EEOC, EEOC offers mediation. If that's available, if your employer is open to that, you know, that's at no cost to you. And if your employer is really open to settling, then you may be able to resolve it during mediation. If mediation fails, then the EEOC will go into its investigation process, which can be, like I said, it can be anywhere from a few months, it can be a year. Um, but once that's done, if the EEOC finds in your favor, they will issue a cause finding against your employer. Okay. And with the cause finding, they'll list out, hey, your employee requested an accommodation. You said that you couldn't grant it, but we believe that you could grant it and it would not create an undue hardship. Okay. Um, and after that, they'll say, hey, we'll offer you an opportunity do you want to conciliate? And conciliation, it's sort of like mediation as well. It's like, look, we're going to request that you pay this person X amount of dollars. We're going to request training, for your employees, this, that, and the third. Um, it's the EEOC is an enforcement agency, but they don't really they can't make the employer agree to it. Because I've had cause findings issued against employers, and the employers just like kick rocks. We don't want to conciliate. We don't care what you said. We don't think we broke the law. Okay. In that instance, the EEOC will decide whether or not they want to actually sue the company themselves. Usually they don't. They take a fraction of a percent of cases that they get every year. Okay. Usually, um, they won't move forward after that. They'll just issue a right to sue letter. Okay. So from the day you get the right to sue letter, you have 90 days to file a lawsuit. Okay. That is a very short window. That's why I always recommend that, hey, even before you go to the EEOC, you talk to an attorney. You get an attorney on board. Okay. because that 90 days is a short time for an attorney, brand new, for you to try to find an attorney and for them to investigate your case and decide if they want to take it to trial. Okay. Trial is intense and it's not cheap. You know, it is thousands, tens of thousands of dollars just in, cost, not even talking about legal fees, just in cost. And if you're out of work and you can't pay that, then you're asking an attorney to front those costs, you know, and they're not sure they're going to get that return on their investment, and that's a big ask for anyone. And not a whole lot of firms are willing to do that within that short window because we got other cases going on, at the same time. So, that 90 days that you have might be only like 30 days for us to try to get something and get it drafted and get it, to investigate your case, get a complaint drafted and get it to the court in time. So yeah, the sooner you get with an attorney, the better your chances are.
Better.
Oh, mhm.
So would you say that if before you even, if you think that you are being discriminated against, the first thing to do, imperative, the first thing to do is to contact an attorney. And do most attorneys give you a consult for free? Is it a free consult or is it a paid consult?
It just depends on the firm. A lot of them do. I don't, because I give a lot of free advice. Like my consult is at a very reduced rate, for my hourly rate, but
Mhm.
it's my time, it's my time, it's my advice. So it's like, if we, if I think you got a case now, I'm not going to, however we move is how we move, like I use a lot of mixed fee agreements. Some law firms, it's straight contingency fee, but like I said, it's a long process. So if I'm
Right,
going to work with you, we're talking like a year or two before we see this thing through, at least.
right.
It's a long process. Um, yeah, so I'm not because you get a lot of me personally, you get a lot of tire kickers, people just shopping around, they want like free legal advice. Um, and I'm not one of those guys. Like I do good work, but it's not free. You're not getting my time for free. I do a lot of educational videos. I put a lot of things out there for people for free at no charge. But
Right.
if you want time with me, if you want time with an attorney, um, yeah, it's going to cost you. And I think most firms are like that. Like you may get some sort of consultation, but it may not be with an attorney.
Right.
You may speak with a paralegal or someone who's like, look, okay, it looks like you might have a case. And then like, later on, you may have to pay a fee to talk to an attorney later on. But with my consults, you talk to me personally. So yeah, my time, I'm not going to charge you my full hourly rate, but I'm going to charge you something, for that time.
So I have a question about
That's
that.
wonderful.
So
Mhm.
when you're doing your consoles, is the determining cost of the counsels you do based upon whatever the claim is, or is it just basically you have a kind of a flat rate, just to get your time to see if you have a case or not?
I'm sorry, I didn't understand. You said is the what now?
So basically, if I came to you for a counsel, right,
Mhm.
and would your charge rate for your counsel be dependent on whatever the case is, or will it be dependent on like you have just kind of a flat rate? I just go and you say, hey, I'm gonna pay this bit of fee just to get your time, just to get started. How
Yeah.
does
Yeah. So the latter. So like, yeah, I have a flat fee for a console. I also it doesn't matter like what the case is. It's a flat fee for the console. But I have some other flat fee services like for folks who have like severance agreements, employee contracts and stuff like that. I'll just do a flat fee. But I want to usually I'll have someone fill out a case assessment. So like I said, my time is valuable. So I use a lot of online systems. So I'll have someone fill out a case assessment form before we even do the consultation. So that way I know I'm like, look, okay, so we may not need to do a consult. Like, um, you may need this service. I offer this service for a flat fee, or like, what you're talking about, depending on what you put in the case assessment, it doesn't sound like you have a case here. you know, just to save someone, you know, like that time and to save my time as well. Um, yeah, I don't have the type of firm where you can just call someone and like call the firm and like speak to an attorney. I got layers before you get to me. Okay. You got I got an answering service. I have a lot of automation set up so that, because like I said, my time is valuable. Um, and most firms are like that. If you're speaking to an attorney, you're paying at least several $100s an hour, you know, to talk to them. My consultation fee is not that much, you know, at all. But like I said, I like to have clients. You got to have some teeth in the game, you know. Like you got to have something invested. You're not gonna waste my time, you know. And people are paying; they're not likely to waste your time.
So let's get to the bone and groans. If I had a case that I wanted to file with you and get your counseling, what would my price be if because it's a flat rate, just to get it
For
started?
the consultation, 175. Yeah,
175. Okay.
yeah, that's for an hour-long consultation. But I'll put it like this: someone's talking about like you get all my years of experience, like and I'll say this too: I'm an employment attorney. I only do employment law. I only represent employees. Like that is important. If I'm talking to another attorney, say like they're representing an employer, I know within the first 15 minutes if they're an employment attorney too, just by the arguments they're making. Like it's not employment law, it's not rocket science, but it is specific. And there's arguments that you can make in other areas of the law that not going to fly in employment law. Okay. So for people who do employment law, like we know the questions to ask, we know like what information matters and what doesn't, you know? So, you know, when I talk about like, you know, when you if you're just going to hire an attorney, they may be a good attorney and they may be able to figure something out, but it's going to take them longer. You know, like I focus my practice on this area of law. So yeah, I'm not just talking out my, you know, out the side of my neck, you know, like I know exactly, you know, what I'm saying to you, you know. And if it's something I don't know, like I'm not like one that I don't BS, you know, like if you got a case, I'm gonna let you know. If it's something I don't know, I'm gonna let you know, hey, I need to research this, you know. If something gives me concern, like I'm gonna let you know. Like I don't hide the ball. Some attorneys like to do that. I'm not one of those attorneys.
Well, Kurt, does employment law also cover military employees
Um,
or armed services? You know, men and women.
it, not necessarily. Like employment, I mean, the military is a little different, but if you're like a reservist and you know, like you need to take leave, military leave, like you know, the USERA laws, like that all comes into play. Um, but yeah, like the military itself, you know, they got their own set, like for active duty, they got their own set of attorneys.
Yep.
Um, yeah.
Okay, so that doesn't fall under employment law with employers.
No,
The military is just
no,
separate.
right, right. I mean,
Unless you're a
if you're a federal
reservist.
employee, right? Yeah, if you're a federal employee, that's different. But like the military is different, you know. Like
Hmm. Okay, that was interesting. Well, Lerone, do you have any other questions you'd like to ask?
My question is, if I wanted to set up a claim, how would I get in contact with you, Mr. Kirk?
okay, the easiest way to is to on my website, www.madlawllc.com. Uh, and I got a contact form up there. You can just shoot an inquiry. Um, it'll ask you for some information and we'll send you a case assessment form, and from there, you know, we'll be in touch with you. But like I said, I automate as much as possible. Also have a you know, you can call the office, but they're probably going to send you to the website 704-981-2790.
And if people wanted to go see your content, like the things you give out when you give out this advice to the public, where did they go to see you? Are you on Facebook, Instagram?
Yeah, I'm on Insta. Mostly I post on Insta. You have Mad Law ESQ. That's my handle, my Instagram handle, and I post a lot on there. Um, those short videos.
That's
Thank you
great.
so much, Mr. Kirk.
Yes. So Kurt, we're going to wrap this up. I want to thank you for an informative discussion on ADA's workplace accommodation, and hopefully you will come back. I also want to thank my co-host Lerone Brown, and of course our
Yeah.
producer, Raw Authentics Culture Pod, Rod Brown, and our viewing audience. And to our viewing audience, we welcome your comments and suggestions for future topics.
And
Peace.
don't forget to subscribe.
Absolutely. Thank you.
Double up. The money I color.